Good afternoon, everyone. This is Can We Talk? And it's March 2nd that we're filming this of 2016. My guest today is Doug Olson from the Brainerd Area Coalition for Peace. And Doug used to be a paralegal. And so I wanted to get his perspective in discussing my petition for review that was filed at the Minnesota Supreme Court on January 21st of the 25th rather of this year. So just last week. And I'm going to go through this and read it, and Doug is going to interrupt me if he wants to discuss something. You're getting it here first, folks, because no one has any knowledge of what's in this. I've read through it, but here we go. It's pretty important stuff. Pursuant to the Minnesota Rule of Criminal Procedure 29.04, petitioner Robin Lynn Hensel is seeking permission to appeal to the Supreme Court from the Court of Appeals. Date of the decision. This is an appeal arising from rulings in a trial where petitioner Robin Lynn Hensel was found guilty of one count of disorderly conduct and sentenced on December 2nd, 2014. Petitioner appealed from the judgment of conviction, and the Court of Appeals affirmed the conviction in a decision filed on January 25th, 2016. Statement of issues, legal issues. Number one is whether this court should hold that Minnesota Statute 609.72 subdivision 1, and then in parentheses 2, violates the First Amendment given that subdivision 1, in parentheses 2, language reaches a wide swath of protected speech and is undefined and amorphous. Rulings below. The district court petitioner's motion to dismiss under the First Amendment, the Court of Appeals affirmed. Number two, whether this court should hold that petitioner was entitled to a fighting words jury instruction given the overbreadth and vagueness of Minnesota Statute 609.72 subdivision 1 in parentheses 2. Rulings below. The district court denied petitioner's request for an expressive conduct jury instruction. The Court of Appeals affirmed. Whether this court, item number 3 is whether this court should hold that under the First Amendment, petitioner was entitled to an instruction that the jury must find petitioner's conduct separable from any message she was trying to convey in order to convict petitioner under Minnesota Statute 609.72 subdivision 1 parentheses 2. Rulings below. The district court denied petitioner's request for a First Amendment jury instruction. The Court of Appeals affirmed. Procedural history. June 7, 2013. Petitioner Robin Hensel is cited for disorderly conduct. September 3, 2013. Complaint is filed in the Morrison County District Court against petitioner, charging her with disorderly conduct under Minnesota Statute 609 subdivision 1 parentheses 2. October 22, 2013. Petitioner files a motion to dismiss. February 12, 2014, district court issues order deny petitioner's motion to dismiss. December 1st, 2014, jury trial begins. The Honorable Douglas Anderson presiding. December 2nd, 2014, jury finds petitioner guilty of disorderly conduct. December 2nd, 2014, Judge Anderson sentences petitioner to 15 days stayed for 1 year pending successful completion of probation and payment of a $50 fine. January 5th, notice of appeal is filed. January 25th, Court of Appeals files its decision affirming petitioner's conviction. Statement of the facts. Petitioner Robin Hensel is politically active in her community and attends almost all Little Falls City Council meetings. And this is me talking now, not on this paper, but the reason I do that is because somebody needs to watchdog this council. In my opinion, every council, every governmental entity, anytime they have a meeting about anything, there should be a citizen monitor at every single one of those meetings, if not a citizen monitor board. That's my feeling after 5 years of watchdog in this group. If we had that in every city and at every governmental meeting, there wouldn't be the mess that we have right now throughout this country. I'm convinced of that.
I totally agree with you, Robin.
A raised dais sits on one side of the council meeting room. At the opposite end are several rows of chairs for the public to use, and between the chairs and the dais is roughly 20 feet of open space. On June 3rd, 2013, the Little Falls City Council held a meeting in the City Council meeting room at City Hall. Chairs and tables had been placed in the open area during a planning meeting that took place prior to the council meeting on June 3rd. Petitioner attended the June 3rd council meeting. She posted signs in the City Hall meeting room and wore one sign on her head. Petitioner was objecting to the fact that citizen appeals had been moved to the non-televised portion of the council meetings. So in other words, this is me talking again now here. That was the first time that free speech was not able to get to the public here over this public television station. The only method I had to get my message to the people at that point was, number one, to wear a hat on my head and have the camera from behind where Chris sits, and he wasn't the manager then, it was a different fellow that was filming, but where the one camera would have filmed, would have picked up the message on my hat. And my hat was about, all total, the hat itself is about this tall, and the sign on top made it about that tall. So I'm gonna guess like up to here, and it was only about this wide. And, well, I'll keep reading here, but that's the reason that it had been moved off the televised version. And at that time, I didn't have a blog. So I didn't have that method to get out to the public either. Prior to that meeting on June 3rd also, I believe the council had limited, actually Lauren Boehm had tried to eliminate citizen petitions and appeals altogether. But instead, the council voted to limit it from 5 minutes, cut it down to 3 minutes.
Which, you know, if I may say something, Robin, is a ridiculously short amount of time to give
It
someone
is.
to make a petition.
It is. You
or
can't-
appeal. 3 minutes? What can you say in 3 minutes? It's very difficult.
Well, you know, as a matter of fact, people have come since they reduced the time to 3 minutes. And if people have an issue other than myself, they oftentimes run out of time and they have to be cut off. I time my stuff ahead of time, so it's a lot of work that goes into every time I give a public forum. You can rest assured I've worked on it a number of hours so that it will fit within that very tiny amount of time.
No, that's ridiculous. They should increase the time limit back to 5 minutes, perhaps even make it a little longer. I mean, 3 minutes? No, when I read that a few years ago, I'm like, what? You know, what can you say in 3 minutes time? Not very much.
Right. Okay, petitioner brought her signs so that the signs could be on TV, as it was important to petitioner to have people consider her message. A handful of other citizens sat directly behind Ms. Hensel at the meeting, including the mayor's husband. This is me talking, I'm gonna stop here. Actually, there were only two people seated behind me. It was former Mayor Van Risingham's husband, George Van Risingham, and his mother. And they sat directly behind me, and then Teresa was to my left. Over here, on the other side of the area where the people usually sit, there's another section of chairs. There's a left side and a right side. And on the right-hand section, 5 other people were there. Linda Burgraff, who is a ex officio on the Historic Planning Commission, was there with her husband and the former Goldsmith owner's wife, Linda Spafford Smith is her name, and Lolly Doucette was there that day, and I think there was a little kid there too that maybe came with Van Risingham's or one of the others. So there were a total of 7 people besides Teresa and I, and then Terry Lurkey for the Morrison County Record, and the guy that was filming, Mike Kretschy, was filming for Channel 6. It was called Channel 6 at the time. Those are the only people there. And there's about 65 chairs in the council area. And 7 people, you know, there was really no reason for them to be allowed to come forward. They could easily see, and if they had objected to my sign on my hat, I would have gladly taken it off and put it on the table in front, because it would have been seen by the camera then. And the rest of my signs were also picked up on the camera, the ones that were directly up front, and even a portion of the one that was directly in front of me. Okay, So that's the reason I wore the colorful outfit and the hat on my head and I had butterfly glasses on, was to just to see what the council would do for one thing, and then to let them know that that was part of my free speech. Because it is. You can dress however you want, and you can wear whatever colorful outfit you want, and you can carry signs, and most meetings you can speak as well. Okay, getting back on track here. Despite the ready availability of additional seating in the gallery, the mayor's husband asked the council if he and other citizens could move to the chairs in the open space in front of the gallery so they could have an unobstructed view of the city council meeting. The council president agreed, and the citizens moved to the chairs that had been placed in the open area during the planning meeting. They had, at the time, 4 oblong tables set up in a square, and each one of those tables is 8 feet long, and so you can put about 5 people on each side of those. And then they had chairs all the way around those, and it took up the entire area. It's set up different now. Since then, they've changed it to, they have 3 tables, and they go at an angle kind of towards the dais, and then one goes straight along with the dais, and the other comes the other way. So it forms like a U shape almost, or a V shape in front of the audience. And when after this happened on the 3rd, and they shut the meeting down very quickly, because when I came in with my colorful outfit and hat, everybody else, not me, not Teresa, we didn't make a peep, but all the rest of them went, oh, and they started to laugh and were loud and obnoxious. And even the city administrator at the time, Dan Vogt, was asking questions and causing a ruckus. I didn't cause a ruckus at all. And matter of fact, Linda Berggraf, who is the owner of Lind Furniture in town here, and this ex officio on the Historical Preservation Committee, walked down the center aisle when they invited the group to come forward. She grabbed my sign, which I had 2 American flags stuck in each side, and when she picked it up, she took it, physically took it to the back of the room. I got up and walked to the back of the room and took it from her. I said, you can't take that, it's mine. She said, so what? Like it didn't matter. This all happened in front of the council. Not one of the council objected to someone taking one of my signs without permission. It was just outrageous. And then when I went to put that sign back, one of the flags fell to the ground. And she didn't care. She turned and looked, and then she said something about, I made a comment about my sign, I think. And she said, well, we don't want to hear what you have to say. So, getting back on track here, sorry about getting off track there a little bit. Just before, the council reconvened on June 7th, 2000, oh wait, I missed one sentence here. Shortly thereafter, the council adjourned, apparently because of the complaints about Miss Hensel's signs. The council reconvened on June 7th, 2013 at 9:30 a.m. Because you know what they hadn't done at that meeting? They didn't pay the bills, which they needed to do. They also, and most people aren't aware of this, they also did not vote to authorize 2 banners that they had to authorize by city council on their own premises. One was at the zoo and one was at the golf course. They didn't authorize them, but guess what? That was on a Monday, that June 3rd meeting. On Wednesday, the city illegally erected both those banners on city property
Without the authorization.
in violation of their own sign ordinance.
Wow. Do as we say, not as we do. Yeah.
Right. Okay. So the council reconvened on June 7th, 4 days later, because they hadn't paid the bills and they hadn't authorized these 2 signs. This meeting was also held in the city hall room, but the chairs and tables had been removed from the open area. I'm going to stop here. This is me talking again. Never in history before, until that time, had they ever, since they started having meetings in the city council room, the chambers, They had never removed the chairs, they had never removed the tables. They did it so that I couldn't move forward and sit in that area. If there wasn't chairs there, they figured I wouldn't be sitting there. Because guess what? At the end of the June 3rd meeting, when all those people had got to come forward, after everybody cleared out, I was talking to Teresa, and Mike Cratchy, this subcontractor for this television station at the time, under Jerry Abraham, was listening. And I turned to Teresa and I said, oh, that's interesting. Since they could sit forward at this meeting, we can sit forward at the next meeting. So he heard it, he knew about it, and I believe that the city council prepared ahead of time and knew that I was going to do what I did because of that. Also, there's never been the captain of the police force and the chief at any meeting prior to that and afterwards.
I was gonna ask you that too. That always struck me as being quite suspicious.
Casillas
that-
was there,
yeah.
and Casillas has retired since then, but Captain Casillas had never been there. So obviously, they knew that I was going to move forward and that it would be an issue.
They were preparing for you.
And the city attorney also was not always at every meeting. She was at some of the meetings. But it was only, I think about maybe a half a year ago, that they decided to have her at every council meeting. Upon, for one thing, my recommendation, because I've told them a long time ago, they should have the city attorney there at every
Of
meeting.
course, that makes sense.
So, back to this. Petitioner's intent in moving her chair was to not disturb the meeting, and that's the truth. I pulled it forward the first time so that I would be there well in advance. It was like, I don't know, 10 minutes before the meeting was gonna start or something like that. And then Jerry Lochner, at the time he was the Public Works Director, grabbed the chair from me and pulled it back into the people corral. He called it the people gallery, I call it the people corral. And he said, you can't sit there.
Now, I have to ask something too, Rob, and I remember at the time that you were preparing for the possibility of a confrontation, that you knew that there might be an issue of you sitting, where the mayor's husband, and was it her grandfather had said, that there was a possibility that they might arrest you or something like that, so you had Lad Fisk there.
Well, see, I had no idea that they would, man, funny because my
But you
attorney
were,
never.
I remember at the time, the discussion, you were thinking, well, I just want to be, just in case they do something.
I didn't know what they were gonna do.
But you did have Lad there to film
Yes,
just
I
in
had,
case.
I had Lad come because I wanted to have, Teresa didn't know how to run the cameras very well.
Right.
And I had just bought a new still camera. But something important to remember here, all throughout this spring, I was getting a lot of threats as well. And so that was a constant, and the council was doing some incredible things. Like, I think it was just at the meeting, one meeting before this meeting, or two meetings prior, I had another camera that I had set on a little table up to the side of the council dais, and they never objected to my cameras being close to them or up by the front or anywhere, because a lot of times I couldn't pick up what they were saying on my cameras if it was back in the audience area. So I put one little camera up close to the dais, but it was on a little side table, and Jeremy Handler brought his pop can and put it right in front of the camera.
And who's
so-
Jeremy Handler?
Well, he's now the council president. At the time, he was a council member.
Wow, yeah.
Unbelievable things.
Oh, yeah. And see, that's why you want someone there to film it, just to see
Right.
what was going on, and so people would believe you, because, truth be said, a lot of people probably, if you were just to say this to members of the public, they'd be like, really? I can't believe they'd do something like that. I think people have a lot of faith. Maybe not so much in the federal government, but seriously, I do think at times people do think that, their local officials are gonna listen to them, and so they'd probably be shocked to hear these things.
Well-
But, if you catch it on camera, then they could see for themselves the evidence of,
Frankly, anything I do in that chamber, whether it's give a public forum comment or anything else, they're bothered by my presence alone. And they certainly are bothered if I wear something different or if I come with a sign.
oh yeah.
I can notice the difference if I bring in even a tiny sign. At one point, my attorney instructed me to take a sign in and have it like a handheld sign. I don't remember what that was about, but I followed my attorney's direction, and the pushback that I get from the council and the ill treatment, the disrespect, and the not following the protocol, treating me the same as they do other people, is incredible.
Yeah.
And so my cameras have all been so that I would have record of everything that happens, because frankly, I don't know ever what's gonna happen.
Well, and I should mention too, that if people are wondering, are you alone in doing this sort of thing? By no means. I mean, I've seen many times before, just reading articles about Tea Party activists have brought signs into meetings, whether it's of state, federal, local officials. Other people have brought in signs. I mean, anytime you might have a contentious issue, maybe there's a vote on something, you might have people bringing in signs expressing their views on this particular issue. So you're not alone in doing this by any
No,
means.
and even Black Lives Matter
Oh,
and some other
absolutely.
groups in the cities now are confronting school board meetings and,
Yep.
and at council meetings. There's been recent things with the Communities Against Police Brutality, that group going in and actually interrupting the meeting. It had already begun.
Right.
And Michelle Gross and David Bickley stood up to the podium and said, we're amending your agenda.
And see, that's right there, if I may make an aside, I could see where you could convict them of disorderly conduct for doing something
Yeah.
like that. But you were never, and we'll go on with the more details, but
Right.
you were never gonna do that. You just wanted to get a better view of what was happening, and basically thinking, well, if the mayor's family can do this, I, or anyone else for that matter, should
right.
be able to do this too.
Right.
And not expecting, you thought that there might be a possibility, given the way they treated you before,
Right.
but not necessarily, expecting them to arrest you and haul you out of the meeting.
I had no idea that could even be considered disorderly conduct, or, because I didn't technically interrupt the meeting.
No,
I
they could have
went
continued the
forward
meeting.
and was intending to sit there
Mhm.
to make the point that my free speech mattered. And also, there was no public forum comment at that June 7th meeting. It was a short meeting, and so the public couldn't speak. I couldn't speak, nobody could speak. So that was my only way to have a voice.
I'm not sure if you mentioned it at all, maybe you do in this petition of the Supreme Court, but there was a city council member, former city council member now, Brian Croder, who, told the other city council members, well, this isn't interrupting the meeting, we can continue.
Right,
And,
right, that's
I
in
think
here.
that's key. I think that is absolutely
Yes.
key, so.
Well, he could understand that, he saw the full meeting before that where the others got to come forward and, the whole thing is just, it's flabbergasting because it's so obvious that they blatantly show preference for certain people. It was only 2 council meetings ago where a man who lives over at the Buckman Building here in town, he's newly returned to town, his name is Jim Mars, came up and spoke during the public forum time, but didn't go to the podium, nor did they make him go to the podium like they do everybody else. He didn't have to give them his address before he spoke. He stood right in the center of where the tables are set up, real confrontational like. Now, if I had done that,
Oh,
they
yeah.
probably would have arrested
I
me.
think so. No, that's true. I mean, well, and I've often wondered, and this might be a bit of an aside from all this, but I think it's part of it too. Ever since you first had your problems with the city of Little Falls, and this is going back over 4 years now, when they told you to take your signs down, I've often wondered, you're a very liberal person, radical, left-wing. If you were on the opposite end of the political spectrum, if you were a Tea Party activist or a religious conservative, a conservative Republican, you had signs out there promoting school prayer, anti-abortion,
Right.
anti-same-sex marriage, anti-immigration, anti-Islam.
My signs would
pro-war.
still be up to date.
I think they would be.
You bet.
I think they would be. I honestly do.
Nobody would have said a thing.
And I think if you were going to the city council meetings and speaking out, I
Right.
don't think it would be as much of an issue. I really
Yeah.
do. That's just my take. I could be wrong, but I have long felt that.
Yeah, it's absolutely right on. It's always been about the content of my speech.
Yes.
And if my ideas are radical, that include treating everybody with decency, showing disrespect, I guess Christ was pretty radical too then, wasn't he?
Yes, he was.
Because I really haven't done anything outside of the clowns in the front yard to show the city council we're a bunch of clowns, and I did that for a reason. And that was, some people might have considered that was a little disrespectful to do that. But again, you're limited in this city as far as how much signage you could have. At the time, it was only 8 square feet. Well, that's that big.
No.
It isn't very big, You can't get a big message in a tiny little area. So I displayed the clowns and the circus in my front yard because I thought it was appropriate. Because council had been behaving like a circus. Like clowns at a circus. And I will still say that. And only the faces have changed. The council is still, in my opinion, performing like a bunch of clowns. And I don't say that lightly. I will go to these meetings and I know the shenanigans that they're still doing. Okay, so we'll get back to this. Petitioner had made her the decision to, petitioner's intent moving her chair was not to disturb the meeting. Petitioner had made her decision that she would move her chair immediately following the June 3rd meeting because she felt she should have the same privilege as those who sat in that area at the June 3rd meeting. Petitioner insists on fair treatment for everyone. That's absolutely true, and that's been since I was a little girl. By moving her chair, Petitioner was trying to convey a message that dissent is patriotic and her disagreement with the city's attempt to marginalize her at the June 3rd meeting. The council asked Petitioner to move her chair back to where the others were placed. Petitioner refused, reminding the council that other citizens, including the mayor's husband, had been allowed to sit in the open area just 4 days earlier. Council members began to speak over one another in raised voices. Not me, they were raising their voices and they were over talking each other. Several demanded that Petitioner move her chair. At several points during the interaction, council members made jokes about and laughed at Petitioner, and there have been too many to count. Numerous incidences of that. Petitioner remained seated and tried to explain her position to the council. Petitioner was not shouting, using obscenities, or making threats, nor was she interrupting the meeting, as it had not yet been called to order. Eventually, Petitioner compromised with the city council members who were complaining and moved her chair several feet back toward where the other chairs had been placed. One council member requested that the council president open the meeting and simply ignore the fact that Petitioner was seated several feet in front of where the other chairs had been placed.
That was Councilmember
That was
Crowder.
Brian Crowder, yes. The council president testified at trial that Ms. Hensel was not preventing him from opening the meeting simply by sitting several feet closer to the dais than the other chairs in the public gallery. Now, at the time, the president council was Don Klinker. Now it's Jeremy Handler, but it was Don Klinker who allowed the group to move forward. Instead of opening the meeting, however, the council summoned the police chief and a city attorney. I'm going to stop right here for a minute because there's something I forgot. The truth is, and one attorney pointed this out to me, and so did a dear friend of mine, if they hadn't made such a big hoopla, the reason that the council meeting couldn't get started was because of them confronting me,
That's right.
not because of me sitting there.
Well, they could have easily followed Councilman Crowder's advice and
Sure.
ignored you if they'd wanted to and just go on with their meeting and not make a big issue of it.
But
Very
then
easily.
they would have had to sit there and look at me
Right.
directly. That's the part they didn't want.
But they could have done it. It was an
They
option.
could've.
See, and that's where
And they should have.
I disagree with the Court of Appeals and for that matter, the district court before them, saying that you would commit disorderly conduct. There was nothing in what you did.
Right.
That, to me, meets the classic definition disorderly conduct.
Right,
You know, you weren't trying to shut down the meeting. You
Right.
weren't interrupting them.
right,
You weren't like doing a sit-in in front of city council or something where people couldn't get through the doors to go. I mean,
Right.
none of it. you
And
know.
I asked numerous times to see the seating arrangement, the seating policy. If they had a policy in place and it said all guests have to sit beyond this line or back in this
Right.
people corral, I would have happily done that. But they didn't have a policy.
Do they have a policy now? To
No.
your knowledge? Okay, so.
They also don't have a policy about cameras. It's a kind of an unwritten rule, I believe, that my cameras have to be behind the podium
Right.
and close to that people corral. Okay, instead of opening the meeting, however, the council summoned the police chief and city attorney. Actually, they didn't have to summon them. They were there. They were there when I got there. They told the petitioner that she would be arrested if she did not move her chair. And actually, Tony Wetzel said I could be arrested. I
She's
think,
the city attorney.
right, I think the police chief said that I would be escorted out. I don't think he used the word arrest.
But in a way, it is an arrest too. I mean, this is just something I remember in my legal studies. If you're not free to leave,
Well, yeah.
you know, if he
they
escorts
detained
you
me.
out, he detained you.
They-
You were arrested, even if he didn't put you in handcuffs.
And not only did they detain me in a locked room. They not only locked the room they held me in, the two officers and me in there, locked it shut. When Ladd was told he couldn't come in there, they forced him out, shoved him out and said, you can't come in here, you're gonna be arrested. He went outside, filmed from the outside window, and they locked down the entire city hall.
Wow. just for this. I mean,
Yeah.
you talk about ridiculous. I mean,
Just to hold me
to
in there.
paraphrase John Wayne in the movie Big Jake, they must think you're a real dangerous woman. You know, you do all this.
Yeah, it's just really, it's funny. It's so sick, it is funny.
It is. I mean, if it weren't, impacting you, a real
Yeah.
person, if this were like some TV show, I mean, it would be kind of funny in an
Yes.
unintentional way.
Yeah. Okay, they told petitioner that she would be arrested if she didn't move her chair. Petitioner responded that she had a right to sit where she was seated and asked to see the city council's policy on chair placement. Roughly 5 minutes after petitioner had moved her chair to the compromised position, Little Falls Police Chief Shermers and a deputy, and that was actually Captain Casillas, removed petitioner from her chair and escorted her out. The deputy then cited petitioner for disorderly conduct. The council called its meeting to order at 9:38 a.m. And who cited me for wrote the ticket wasn't Casillas and it wasn't Greg Shermers. They had David Stevenson do it, a different officer. Now, here's something interesting about David Stevenson. He's either no longer with the police force or he's gone on active leave with the military. I don't know, but he's not here anymore. He also wrote the citation for my sign violation, and I received the only actual citation for a sign violation ever in the history of this town. So he wrote that petition. And there's another incident with him too, and I'm trying to think what that is now, but I can't think about it. But there's 3 key things with me, and it was all him that was involved with it.
You think he has a bias against you?
Now, I think maybe he's Chief Shermer's go-to guy.
Yeah.
I think he's the one that gets designated to give me the bad news. I don't know, I'm just guessing.
It is a bit of a coincidence,
Yeah.
same officer all 3 times.
Right. Okay, reasons why the Supreme Court should grant review. This is kind of getting into the meat of this. And I about dropped my jaw when I read this. This case warrants review by the Supreme Court for several reasons. First, it involves an important question of public interest. The extent to which constitutional guarantees of free speech protect citizen engagement and activism at government meetings. Second, it involves the constitutionality of a statute, Minnesota Statute Section 609.72, Subdivision 1, in parentheses 2, which the Supreme Court has not yet addressed. Third, the Court of Appeals ruling on the constitutionality of Subdivision 1, in parentheses 2, is inconsistent with the Supreme Court's analysis and narrowing of other prongs of the disorderly conduct statute. Finally, resolution of the questions in this appeal is of statewide impact not only for those politically active citizens seeking to express themselves at government meetings, but also for the media and other politically neutral actors who nonetheless have a central role at such meetings. Number A, the case presents an important question upon which the Supreme Court should rule. This case presents issues that concern core First Amendment rights to dissent and express dissatisfaction with elected officials, as well as to participate in or monitor local government meetings. A decision by the Supreme Court will clarify the extent to which speech and expressive conduct are protected at local government meetings and the reach of Minnesota Statute 609.72, Subdivision 1, in parentheses 2.
I think that's very important there too, because this will let people know, such as yourself and anyone else who really wants to express themselves, what conduct is permitted and what's not, what falls under the disorderly conduct statute, because I think as of right now, it's not quite clear.
Well, it isn't. And why would the Minneapolis Council, who has no public forum comment at all, for anyone to come and speak at their podium, and when the 3 people, Michelle Gross, David Bickley, and another senior citizen gal, and I can't remember her name, stood up, interrupted the meeting after it had begun, said, we're amending your agenda, and they continued to talk right on, even though they were asked not to. They had to be escorted out, and Michelle Gross was yelling in the back of the city council meeting as she left, "We will be back. You will hear us," or something like that. They didn't arrest any of them.
Right.
Didn't give them a citation at all. Didn't detain them either in the hallway. They just took them out and let them stand there.
So basically, there's really no standard. It's all up
There
to
isn't.
city council.
Right.
And that's dangerous too, because
Right.
that can be so capricious. So people can do things like that, which are really disruptive. I mean,
Right.
I agree with a lot of what the Black Lives Matter movement advocates, but I would say that their conduct there would be disruptive and would fall under the disorderly conduct statute. But they can, get away with doing that, because the city council decides not to, press charges, not to have the police arrest them, and yet you do something, you're sitting in a chair, not bothering anyone.
Right.
And then they haul you off and
Right.
arrest you and you're convicted of disorderly conduct. I mean, something just doesn't feel right, about
Right.
that. I mean, and this is where the court has a real opportunity.
I think it was at a recent school board meeting in the Twin Cities where I believe it was 12 Black Lives Matter activists stood up in between the dais where the school board members were seated and the audience, and they stood up, faced the audience, and stood there till the meeting was shut down.
Right.
And they weren't arrested. They weren't hauled out.
No, and see, that's the thing. I mean, there needs to be some standard as far as what conduct,
Right.
falls under disorderly conduct, what's not. And I would say the examples you gave of the Black Lives Matter activists, I mean, that seems to me to be much more, disorderly conduct. I mean, to me, the core issue is this: what disrupts the meeting, And what they were doing would disrupt the meeting, and that, the disorderly conduct statute says that, disrupting a lawful meeting is
Right.
disorderly conduct, whereas what you were doing, is not disrupting the meeting.
Right.
And so this gives the Minnesota Supreme Court the chance to say, okay, what is disrupting the meeting? Is it disrupting the meeting for you to bring in your signs, or for anyone else to bring in signs?
Right.
Is it disrupting, the meeting to hold up posters or banners or something like that?
And they don't have a policy on that either.
No, I mean, so there's questions about that.
Right.
What exactly is disrupting a meeting?
Right.
And this is where I really hope the court, takes your case, and then they can set some standards. And I hope, of course, that, that they rule in your favor, because what you did was not disrupting the meeting. You had no intention of disrupting the meeting.
Right.
Had the little Falls City Council let you just sit there, go on with the meeting, we wouldn't even be here discussing this today.
Right. Item B, the Court of Appeals ruled on the constitutionality of Minnesota Statute 609.72, subdivision 1, parentheses 2. The Court of Appeals ruled on the constitutionality of section 609.72, subdivision 1.1, in parentheses 2, but incorrectly concluded that the statute was not unconstitutionally overbroad or unconstitutionally vague. Subdivision 1, parentheses 2, prohibits disturbing a lawful assembly or meeting. A review of the plain language of the statute shows it is almost without limit and captures a wide swath of First Amendment
I want to mention
protected
one other
speech.
thing I hadn't thought about. I think I may have mentioned this in emails too. Some other conduct that could be, if you really had a very, liberal interpretation. When I say liberal, basically allowing just about anything to fall under disorderly conduct. But sometimes when people want to make a symbolic protest gesture, they'll turn their back on a speaker.
Right,
Or, what if you're booing? Not heckling so loud.
right.
But, just kind of hissing a little bit. Would that be considered disorderly conduct? I mean, so there are a lot of questions for the court to address here.
Although this case involves alleged disruption of a government meeting, the statute is not limited to government meetings. A meeting can be two people talking on the street.
Right?
For example, the American Heritage College Dictionary defines meeting as an assembly or gathering of people. Likewise, an assembly can be two people gathered together in the same place for a common reason. For example, the American Heritage College Dictionary defines assembly as a group gathered for a common reason, as for a religious or social purpose. To disturb, as the Court of Appeals explained, means to break up or destroy the tranquility, order, or settled state of. And that says ADD 8 in parentheses. I don't know what that means. The Court of Appeals declined to apply a narrow construction to subdivision 1 in parentheses 2. Thus, if one breaks up the tranquility of two people talking on the street through any speech or expressive conduct, not just through fighting words, one has committed a crime under subdivision 1 in parentheses 2.
That seems pretty broad to me.
This
It really does.
statute is not only narrowly tailored, it is barely tailored at all. Now that's profound. That's the part, when I read that, I almost fell over, because And this has to be true, because these guys,
They're lawyers.
this is
you
what
know.
they do, they're criminal
Right.
attorneys.
You know, the other thing is too, and maybe you mentioned it later on, or this appellate brief does, but other courts, you know, in other states have narrowed, you know, these disorderly conduct statutes, and they've clearly said what is disorderly conduct and what is not,
But not Minnesota.
but not Minnesota. And this is why this case is so important.
The amount of core free speech and expressive conduct encompassed by the statute, as currently construed, is breathtaking. Any speech that breaks up the tranquility of a local government meeting, for example, is criminal. The district court recognized the breadth of the unrestricted statute sweep and chose to apply a fighting words construction to subdivision 1 in parentheses 2 to save it. For example, the district court noted Ms. Hensel's clearly protected speech at the June 3rd meeting displaying handmade signs she brought to the meeting that disturbed others and purportedly led to the meeting's adjournment would have been criminal without the narrowing construction. The district court therefore applied the fighting words narrowing construction, though its failure to give proper jury instructions rendered this narrowing construction moot. You want to explain what that means?
Moot means it's just not an issue, because had the judge, you know, Judge Anderson, explained that to the jury and given them instructions cognizant with his narrowing of the interpretation of the statute, they may have ruled in your favor, they may have acquitted you. But since his jury instructions didn't do that, then it became a moot issue, you know.
Right. Well, they would have had to consider then that I hadn't used any fighting words.
That's right.
And if truly you have to use fighting words in order to have a disorderly conduct charge,
Oh.
then they erred.
And
Completely.
And again, I mentioned other courts in other states, and that's what those courts have held. You know, is that you have to basically use fighting words. You have to do something that really disrupts the meeting, not just maybe embarrasses the city council people or the other government officials, not something that, you know, might make them feel a bit uncomfortable, but it really has to disrupt the meeting, you know, in a real substantive way, where they're like basically forced to shut it down.
Unlike the district court, the Court of Appeals held that no such construction was necessary.
Big mistake on their part, as far as I'm concerned. Big mistake.
Without such a narrowing construction, however, the statute is both overbroad and void for vagueness.
And it's not like the Court of Appeals, I've read their opinion, they knew about these other court decisions, they just chose not to,
Right,
you know, follow them.
right. Subdivision 1 in parentheses 2 is unconstitutionally overbroad. A statute is overbroad on its face if it prohibits or chills a substantial amount of protected speech along with unprotected speech. And it lists State v. Crowley, 819 N.W. 2nd, 94, 102, Minnesota, 2012. Do you think I should read all those cases?
Don't necessarily have to, you know, if you just want to cite the case.
Okay, I'll just cite the case as we
Yeah.
go along, because there's a lot of cases cited
There
here.
are, so it might take a while, you know, for people.
Well, at least they can look them up if they want to.
Sure, you know, type in the name of the case and they
Right.
should be able to find
The
it.
only categories of unprotected speech are obscenity, defamation, fraud, incitement, and speech integral to criminal conduct. Crowley, that's the case, citing United States v. Stevens. Accordingly, a statute is unconstitutionally overbroad if it prohibits or chills a substantial amount of speech that does not fall into one or more of the above categories.
I want to just stop here for a second, Robin. That's a
Okay.
pretty narrow group of categories. I mean, obscenity, defamation, fraud, incitement, and speech integral to criminal conduct. In other words, basically everything else is permissible.
Mm-hmm,
I mean, that is right there. And you didn't do anything.
right,
When you were at that city council meeting, that would be obscene, defamatory, wasn't fraudulent, you didn't incite anyone, and you weren't doing anything that would further a criminal objective. So what you did does not fall into any of those exceptions.
right. The Minnesota Supreme Court has already determined that at least one subsection of the disorderly conduct statute is overbroad on its face. In INRE welfare,
INRE, yeah, it's INRE welfare,
INRE welfare of
SLJ.
SLJ,
That's
the
what
court
courts do when they
determined.
have minors.
Oh, yeah.
Yeah,
That's
they
a
don't-
minor case, yeah. The court determined that Minnesota statute 609.72 is overbroad and vague. Yeah, okay, let's go on to this. Whoever does any of the following in a public or private place, including on a school bus, knowing or having reasonable grounds to know that it will or will tend to alarm, disturb, anger, or disturb others or provoke an assault or breach of the peace is guilty of disorderly conduct, which is a misdemeanor. Item number 3 engages in offensive, obscene, abusive, boisterous, or noisy conduct, or in offensive, obscene, or abusive language tending reasonably to arouse alarm, anger, or resentment in others. I also didn't do any of those.
No, none of those, and yet even the court said that that was going too far.
The court explained that the above
Yeah.
subsection punished words alone and thus was unconstitutional as written.
The court gives a lot more protection to words than they do to conduct. You know, they really do. They want to protect people's right to express ideas, you know. So just about any speech is allowed, other than the narrow exceptions you mentioned earlier. Conduct, there are some more restrictions, but yeah, anything that would punish you just for your ideas is not allowed.
The court explained that it could save subdivision 1 in parentheses 3's constitutionality by construing it narrowly to refer only to the fighting words category of unprotected speech. As a threshold matter, the Court of Appeals should have applied the fighting words narrowing construction to Minnesota Statute 609.72 so that the second prong of the section is consistent with the third prong of section 609.72. The Court of Appeals reasoned, however, that the narrowing construction did not apply to Minnesota Statute 609.72, subdivision 1, parentheses 2, because that provision was a conduct-based prescription. The Court of Appeals observed that subdivision 1, in parentheses 2, on its face prescribes disturbances of meetings which certainly could take the form of speaking out of turn, heckling, shouting, chanting, and other forms of oral protest. In other words, the statute captures a wide swath of pure protected First Amendment speech. The Court of Appeals applied the time, place, and manner restrictions test from Clark v. Community for Creative Nonviolence, 1984
And
case.
that's a U.S. Supreme Court decision.
Right, notwithstanding the fact that subdivision 1, in parentheses 2, contains no limitation on time, place, or manner of conduct, but its face merely prohibits disturbing conduct anywhere two people may be meeting. The Court of Appeals then reasoned that subdivision 1, parentheses 2, is narrowing tailored because it is reasonably understood to reach only conduct, including speech, that would be expected to interfere with the ability to conduct a meeting. Yet this clarifying language is nowhere in the statute and was certainly not a part of any jury instruction given at trial. Absent of fighting words narrowing construction, subdivision 1, parentheses 2, is not narrowly tailored and prohibits, in parentheses, and will chill substantial amounts of protected expression, including almost all public protest at city council and other government meetings, not to mention non-governmental meetings and assemblies and rallies. Ironically, under the current construction of subdivision 1, parentheses 2, a speaker addressing a rally of like-minded individuals could commit a criminal act simply by breaking up the tranquility of those attending through an especially passionate speech. Subdivision 1 is unconstitutionally vague. A penal statute can violate the void for vagueness doctrine in two ways. Number one, if it fails to give a person of ordinary intelligence fair notice that his contemplated conduct is forbidden by the statute, or two, if it authorizes or encourages arbitrary and discriminatory enforcement.
This is key. This language right here is key, Robin, because we've already talked about this, that, number one, there are really no standards with this law. It's very broad. It could cover, things that ordinarily would not be considered disrupting a meeting. For example, turning your back on a speaker, maybe quietly booing or just shaking your head or holding up a sign or banner, things that the meeting could still continue. But it's possible, under the way the statute is interpreted now, that could be considered disorderly conduct and a person could be arrested for those things. And then the other thing is, like we've already talked about, arbitrary and discriminatory enforcement. Look at what the Black Lives Matter activists did down in the Twin Cities. I would consider that to be disruptive conduct that would be fairly considered to be disorderly conduct. I mean, don't get me wrong, I support, again, a lot of what they're doing, and sometimes, you know, you have to commit civil disobedience. But I would certainly consider that to be disruptive conduct.
Right.
Right or wrong as far as, you know, the values of what they're saying. But like you said, none of them were charged with disorderly conduct.
Right. Well, their
Whereas-
intent was to shut the meeting
yeah,
down.
shut the meeting down, whereas you had no such intent whatsoever.
Right.
You just wanted to make a point,
Right,
and the city council could have still held the meeting.
right.
But instead, they drag you away, arrest you, and. you
Lock
know-
me in a room
Yeah, lock you in a room.
For 30 minutes.
And we're going through all this rigmarole. So
Right.
it is way too arbitrary.
Right.
You know,
And so then it cites the case State v. Ness. That's the 1985 case. Oh, no, that's a 2012 case. And then State v. Newstrom, a
From
1985
1985, yeah.
case. The Court of Appeals held that subdivision 1, parentheses 2, is not void for vagueness, reasoning that it viewed in context, the statute can be understood by persons of common intelligence as prohibiting conduct that could be expected to interfere with the ability to conduct a meeting. The Court of Appeals erred for 2 reasons. First, subdivision 1 provides only that if a crime is to disturb a meeting, an assembly or meeting, if done knowing or having reasonable grounds to know that it will or will tend to alarm, anger, or disturb others or provoke an assault or breach of the peace. Subdivision 1 does not explain what it means to disturb a meeting, nor does it provide any sort of threshold for that disturbance. That's just basically what you've been saying.
yeah, absolutely. That's.
Accordingly, persons of common intelligence are left to guess at the meaning of the statute and may differ as to its
And
application.
here's the thing that's fundamental about law, about the rule of law. You should never, ever have to guess at the meaning of a statute. It
Right.
should be clear cut. A person of average intelligence should be able to understand what the statute means, so therefore he or she knows what conduct is allowed and what is prohibited. You don't have to guess.
Right. And if it was so important that you couldn't, nobody was gonna be allowed to sit or be in that area between the council dais and the chairs where the audience usually sat, then why in the world years ago, didn't they develop a seating policy?
That's right.
Or a camera policy?
Absolutely right.
Or a sign policy?
That's right.
Or you can't sing at the podium, like Larry stood up there. They could have, I suppose.
They could, but
Have arrested him
I
for
honestly
singing.
think that some of those policies, you know, like the singing, you know, or for that matter, not allowing cameras in certain places, I think that would run afoul of the law. I really do. You know, that would be, you know, if you arrested Larry for singing his Camp Ripley Blues protest song.
Well, they would have violated his.
Oh, that's free speech. That is core of free speech. That is fundamental. You know, I'd like
Right.
to think that there's no court in the land that would allow them to get away with that. I
Right.
really do. I mean, that would be outrageous. I mean, even worse than what happened to you. I mean, my honest opinion, that would be, how could you ever even make an intelligent argument that that is some way, you know, disrupting the meeting? He's just singing a song within the 3 minutes that they gave him. He managed to do it, though. That's amazing.
Yeah, we have 5 minutes left, which will be just about the right time to finish up. But before we go any further, I want to make a comment. I'm wondering how far Morrison County Attorney Brian Biddendorf's and Paul Reavers, who represents the League of Minnesota Cities, and their attorneys' tentacles reach. I wonder if their tentacles reach all the way down to the Twin Cities to the Supreme Court. That's what I'm
Well,
wondering.
You may find it out when the court, hopefully, agrees to hear your case. But I'm hoping that there are no such tentacles and that the court can hear this in an objective manner and judge it based on the facts and on the law, and that they can really make a ruling that clarifies what the statute is.
And I should clarify what I mean by that. What I mean by tentacles are political
Connections, you know.
connections that sometimes pranks are pulled or shenanigans are pulled where certain county attorneys or certain other attorneys get by with influence of judges.
That's right.
Because we know that happens.
Now, is there another part of this? Decision by, yeah, that's key right there. Decision by the Supreme Court will help develop and clarify towards the end of the,
Yeah, we're going to need to go over just a tad here, Chris, probably. Second, the language in subdivision 1 is undefined and amorphous, and as discussed above, lacks any helpful threshold regarding what conduct rises to the level of a violation. Accordingly, judges and jurors will be free to decide without any legal fixed standards what is prohibited and what is not in each particular case. And then they cite Giaccio, and that's Giaccio v. Pennsylvania. It's a 1966 case. Without a narrowing construction, this becomes particularly problematic and opens the door to punishing individuals for the message conveyed by their expressive conduct if that message is found to disturb. In light of the foregoing, the Court of Appeals also erred in holding that the district court did not err by denying Ms. Hensel's requested jury instructions. Item number C, a decision by the Supreme Court will help to develop and clarify the law, and the resolution of the question presented has possible statewide impact.
I believe it does.
As alluded to, and in the discussion above, oh no, wait, excuse me, let me start again. As alluded to in the above discussion, the law in this area needs clarification in part because the interpretation of the second prong of the statute is now inconsistent with the third prong of the statute. Resolving this issue and other issues presented in this position will help bring clarity to the law and will have an impact on citizen engagement and activism at government meetings throughout the entire state.
Excellent, yeah, that.
And even non-government
And that's from
meetings.
your attorney,
Kevin Rich,
Yep.
and his helper is David D. Coyle.
Yeah, and I've always been impressed by his briefs. They're well-written and easy to understand and very persuasive. It's a shame the Court of Appeals didn't rule in your favor. I think they should have, and we can probably discuss that in the next episode, why they should have ruled in your favor and, you know, how they ignored some of their own precedents, you know, and other court decisions. But no, he's absolutely right. What he's saying there is we need clarification of the statute so people know if they want to become active in their local government and go to meetings, what conduct is allowed and what is not. Otherwise, you leave it up to the discretion of the city council, to the police force, to local, you know, the district attorneys, the judges, juries. And
School boards,
yeah, school
everybody.
boards, absolutely. That's a good point.
Even meetings like with the Tea Party or,
Yes.
you know, a governmental meeting up at the courthouse or whatever.
Absolutely. It could be any meeting, and it leaves way too much discretion. So basically, if the jury likes your point of view, well, they'll acquit you. If they don't, you're convicted.
This
And
could even carry over into churches,
conceivably.
because those are meetings.
Yes, they are. 'Cause, yeah, they are. They are meetings. I mean, you know, people meeting together for a common purpose. You know,
That's
they're
right.
worshiping. So yes, it could.
Well, thank you very much for watching. We'll have a second episode that we're going to film now next, and that will air on the same day, hopefully that at a different time that this episode's going to air. So thank you, Doug, for joining me today,
Absolutely.
and
Happy to be
the
here.
next episode will be continuing this discussion. Thank you again for watching, and have a great day.